September 15, 2022 meeting of the Georgia Government Transparency and Campaign Finance Commission meeting to order. I've got an agenda that's been prepared for us here today. Is there any, are there any changes that are necessary for the agenda that we know of at this point, any preliminary hearings that are becoming consent orders or anything of that nature? No. All right, I'll go ahead and make a motion that we adopt the agenda as presented. Do I have a second?
Second.
Got a motion and a second. Do we have any discussion? Hearing none, I'll go ahead and call the question. All in favor say aye. Aye. Any opposed? The agenda is adopted as presented. We'll go ahead and start moving through that agenda. We'll be on item number 3. We'll start with the preliminary hearings.
With the minutes.
I'm sorry. Forgot we had to approve the minutes. Thank you. We have 2 sets of minutes. I don't know if everyone had the opportunity to review those that were with the packet. And we'll start first with the minutes for the regular meeting that we had on July the 12th of 2022. My review of those initial minutes showed that there was one change, I believe, that was on page 5. It was under the application for agency review. It was in the case of, in the matter of school reform 2016. It indicated that there was an attorney there present for that hearing that actually was just a holdover from the prior case. That wasn't correct. The attorney was present. So that was removed from that. And subject to that change, did anyone else note any changes that needed to be made to the minutes of that July 12th, 2022 meeting? All right, I'll go ahead and make a motion that we adopt those minutes of the July 12, 2022 meeting as presented with that one change noted. Got a second?
Second.
I got a motion and a second. Any discussion? Hearing none, I'll go ahead and call the question. All in favor say aye. Aye. Any opposed? All right, those meetings are adopted. We'll now move to the minute meetings for the special meeting that took place on August 1st of 2022. There were a few changes that were made to those minutes that were in our initial packet. First, there was a reference to that being a regular meeting that was changed to it being a special meeting that took place. And then I believe on item number 2 that was in there, where the motion was referenced, there wasn't any indication of the motion second and vote where that was added. It showed that it was motion seconded and then carried 5-0. Anyone else note any other changes to those minutes? All right, I'll go ahead and make a motion that we go ahead and approve, subject to those changes, the minute meetings for the August 1st, 2022 special meeting. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, those minute meetings are also approved. Again, thank you, Mr. Amati, for reminding me that we had to do that. We will now move to item number 3 on the agenda. We'll start with the preliminary hearings. I'm going to call case number 22-0104C in the matter of Chad Jones-Smith. And who do we have this morning on behalf of the commission?
Jacob Pruitt on behalf of the commission.
All right, Mr. Pruitt, is anyone here on behalf of Chad Jones-Smith?
Not to my knowledge.
All right, Mr. Pruitt, go ahead and proceed.
Mr. Jones-Smith was a candidate for the Atlanta Public Schools Board of Education. Was a candidate for the Atlanta Public Schools Board of Education District 2. He declared his declaration of intent to accept campaign contributions on May 15, 2019. He lost the race.
Mr. Pruitt, I'm sorry to interrupt you. Move that microphone a little bit closer. There you go. Is that better? Yeah, that's better.
And there has no termination of campaign has been filed. In September of 2019, candidate filed a CCDR with a negative campaign balance on hand, with summary reporting itemized expenditures of $3,502.05, but only actually itemized $2,508.44 of expenditures. Respondent failed to disclose expenditures in violation of 21-534. Respondent filed his December 31st, 2019 CCDR on January 10th, 2020, 10 days after it was due and 2 days after the expiration of the grace period. The report is also a zero report where there are no actual disclosures, including the carryover of the negative balance. And that's just an example of there's nothing there. It's all zeros. They just clicked it and filed it. We allege that the respondent failed to disclose his contributions on his September 9th, 2019 CCDR in violation of 21-534B1, since there was a negative balance, there was money coming in that was not going out. He failed to disclose all of his expenditures on the September 9th, 2019 campaign contribution disclosure report, since there was a discrepancy between what he claimed was itemized and what was actually itemized. And he also failed to timely file his December 31st, 2020 contribution report in violation of 21-534C2. And when we filed this complaint, respondent reached out to us, and when we told him that there was going to be a late fee and a civil penalty, he was like, just put me on the hearing. So that is why this is before you.
Is that the last that you heard from him?
Yes, it is.
How long ago was that?
2 months.
Okay.
You know, he contacted me, and I spoke to him on the phone and explained that, you know, he had the late filing, and that was really all we were concerned with until we started digging into it. And he was outraged that there was going to be, it was going to be $250, include the late fee and the civil penalty for the late filing, and told me that I should just put him on the hearing.
And then you found the evidence that
And then I started
on the
looking-
disclosure form, it just intentionally put zeros as if he wasn't even going to try to fill it out correctly.
Exactly.
Okay. All right. Commissioner Hicks?
So I guess my question, do you think it was intentional, or is it just that, you know, candidates have a hard time trying to figure out how to fill out these disclosures? They should know how, but nevertheless, over and over again, they just fill them out wrong.
It is an ATS, so it's filed with the Atlanta Elections Office, not through our system. But he still had to pick up the form. They're still filled out by hand. So he just didn't do anything.
Is he in agreement to your fines? And
No, he felt like the fines and penalties were unreasonable, and so requested to be put on the calendar for a hearing.
And I'm sorry, I just want to follow up on one more thing. I want to go back to the filling out the form. He has to manually fill out that form. So did he manually fill out the form with the zeros, or did he just not fill out the form?
He just filed it without doing any actual work on it. So it has a timestamp, and he signed it, but really all you have to do to file in the easy vote system that Atlanta uses is fill out your cover page and then file it.
Okay. Mr. Thompson?
But he did follow it. He did put,
He
did
filed
put
it
numbers, he did put contributions.
on the September 9th one.
Right, so he knows how to do the form.
He
Okay.
clearly knows how to do it, he just didn't.
I just wanted to make sure we were on the same page, because it sounded like there was nothing reported, but there is.
No, the first CCDR that he filed in September has contributions and expenditures, and the second one he filed late for December is just zeros. It just has the cover page filled out, and that's it.
Commissioner Hicks?
just one more question. So he stopped communicating with you and basically just said, put him on the hearing.
Yeah, when I said, there's this issue and we can file a consent order,
Mhm,
it'll be $125 statutory late fee, $125 civil penalty.
mhm.
And he said, I don't think that's fair, it was only 2 days late. Just put me on the calendar for a hearing. And that was the last I heard.
Commissioner Watts?
Is the, just so I'm clear, is the violation that he's 2 days late?
That
It's also,
is,
or I guess it's also that he didn't fill it out correctly.
well, there are 3 violations after going over his reporting. One is that he had a negative balance, so there were contributions that were not reported. He made expenditures that didn't account for money coming into his account. The second is that he didn't report all of his expenditures. In his summary page, he reported that there was $3,000 and some odd dollars of expenditures, and when we went through his actual expenditures reported, there were only $2,000 and some odd. So there's around $1,000 difference in between what he reported as itemized expenditures and what he actually itemized as expenditures. And then there is the late filing, and it was 10 days late.
10 days late, okay, thanks.
All right, I'm going to go ahead and make a motion that we find that reasonable grounds exist that the Campaign Finance Act was violated for the reasons alleged by the commission staff, which include 2 violations of 21-534B1 and 1 violation of 21-534C2. Second.
Second.
Got a motion and a second. Do we have any discussion?
I have a procedural question.
Sure.
So, understanding that you stated in the motion what the violations are, so when we're voting for what we say in our motion and not necessarily the complaint that we have in front of us, because some of this in the complaint, it only says that he's missing December 2019 and contributions. So I just want to make sure we're not voting on what the staff presented in our binders, but rather what comes out of our motion.
Well, it is going to be what's coming out of the motion, but it's my understanding, and the way that I phrased the motion was that we're going to find that there are reasonable grounds to exist that the violations are present for the reasons that they allege, which I was just summarizing what the violations are that they presented to us.
And I agree
Are
with
you saying
that.
that's not consistent with what's in the complaint?
Well, right here, if you look on page 20,
Okay.
and I know we had this, the only reason why I'm asking this is because we've had this before.
We have.
Well, we bring it to OSA and they say, you didn't, I'm just trying to figure out procedurally.
No, I think it's a good point.
See, this is all I said.
The allegations are in pages,
Paragraphs 8, 10, and 11.
of the original complaint.
And it's those 3 allegations, right?
Yes, sir.
Okay.
34 C2A.
It's 2 violations of B1 and 1 violation of C2.
Okay, I was wondering, because I'm.
Yeah.
Yeah.
Okay.
And I've just been informed that all that means is that once we vote on it, he has 30 days to make any corrections and clear it up and agree to fines, right? Or he goes.
Or it's going to be referred to the Office of State Magistrate hearings.
All right.
Yeah. So there's a motion on the table. There's a motion and a second on the table. Any further discussion? All right, hearing none, I'll go ahead and call the question. All in favor say aye. Aye. Any opposed? Hearing none, that motion carries. Thank you, Mr. Pruitt. Next case on the calendar, I'm going to call case number 22-0089C in the matter of Khadijah Abdur Rahman.
Khadijah, yes, sir.
Khadijah, okay. Mr. Pruitt, this is yours again.
Yes, it is.
Is anyone present on behalf of the respondent in this case?
She has said that she will not be present today.
Okay, she's not online or by Zoom or anything?
No, she apparently had an emergency medical thing yesterday, so.
Oh, wait.
But there's a letter here in the files, right? Looks like
Yes.
we got a letter.
It's in,
Yeah, she did have her assistant send us a letter yesterday. That was in my email when I logged on this morning.
So can you just summarize, excuse me, can I?
go ahead.
Can you just summarize why she's gone or why she's not here?
She had an outpatient surgical procedure that she called me about on Friday to let me know, even though she had notice of this hearing a month ago.
Yeah, okay, so since I've been on this commission, I've been talking about notice and due process for I don't know how many years. And I'm a practicing attorney, and if and there's a lot of grace when there's a medical issue, right? Even if it occurs on Friday. And we've also had situations where we've,
But
hold on, where we've deferred in situations that I didn't think that we should. But look, if my feeling is if she called on Friday or let you know on Friday that she was going to have an outpatient procedure done, then we should table this, give her notice for the next hearing, and give her an opportunity to be
If I
heard.
may, when she called me on Friday, she said that this procedure had been on hold for months. So she had notice that it was going to be happening yesterday, but did not contact us when she got notice of this hearing. She waited until
Okay.
the Friday afternoon before.
And Commissioners, I would think this case, the way they have responded, we believe this.
No, I know where you're headed with that, because I mean, I can read the letter, but I'm personally with Commissioner Watts on this one. Again, I'm going to give her, grace and the opportunity to actually have, to be able to appear before us and to argue her case. Commissioner Watts, do you want to make a motion on this one?
Yeah, I'm going to motion to table this preliminary hearing until the next formal meeting, and request that the staff provide due notice that they normally do as such.
And I'm going to second that, and so the motion's on the table, and the discussion, I think Commissioner Watts wants to say, Commissioner.
Yeah, I just want to say, is she working with you?
No.
This letter indicates that she's doing something
Well,
with you.
Other than delivering her bank records on July 6th, she has had no contact with us.
Mhm.
She has not responded. When the notice of additional allegations was filed, as well as the notice of the hearing, there was no contact from her or her office until last Friday, when she called and said that, well, I have this thing that has been scheduled for 6 months and I can't get out of it. And also, I'm trying to get things together to amend and refile and correct filings from as far back as 3 years ago.
If I look at what, and this is my last point, because I'm in agreement. If I look at what this document and what's in the files, it looks like she had a lot of stuff to do, and a lot of reports to amend.
There are a lot of issues with
Okay.
both her filings and her accounts.
Okay, all right, thank you, sir.
Any further discussion on the motion? All right, hearing none, I'll go ahead and call for the question. All in favor, say aye. Aye. Any opposed? Hearing none, that motion carries. So we'll make sure that that case is scheduled for our next regular meeting to make sure that she's provided due notice.
We will let her know immediately that she is on the calendar for December.
Okay. Thank you, Mr. Pruitt. Next case, last preliminary hearing that I have is case number 22-0063-C. It's in the matter of Thomas Dean. Mr. Pruitt, it looks like you're lucky enough to have all three of these cases.
I'm up here all morning.
All right.
Thank you.
Is there anyone here that is present on behalf of Mr. Dean?
I am here.
Mr. Dean?
Yes.
All right. Glad to see you this morning. Appreciate you coming. We'll go ahead and we'll give you an opportunity to respond after Mr. Pruitt presents the case on behalf of the commission. Mr. Pruitt, go ahead.
Mr. Dean was a candidate for Georgia Commissioner of Labor in the 2022 election cycle, qualified as a candidate on March 7, 2022, and unsuccessfully ran in the Democratic primary. The commission filed a complaint on June 6, 2022. for a failure to file a personal financial disclosure statement, and upon discussion, respondent requested a hearing before the commission. That's just the disclosure statement that, or the code that every candidate is required to file a personal financial disclosure statement. Statewide candidates are required to file an enhanced financial disclosure statement for the preceding calendar year. As of this morning, respondent has not registered with the commission, has not filed a personal financial disclosure statement, a declaration of intent to accept campaign contributions, nor a contribution disclosure report. We have no evidence that he has either accepted or made expenditures in regards to his campaign, so we are not alleging that there's a violation there, but he has not registered with us and he has not filed a disclosure statement. There is a standard late fee for statewide candidates. It's a late fee and civil penalty. Combined is $1,125 for failure to file or late filing of a personal financial disclosure statement for a statewide candidate. The respondent protested the amount of the fee and requested to have a hearing before you. And this is just a screenshot showing that he's not even registered in the financial disclosure.
Commissioner Watts, go ahead. This is so kind. The fees are the standard fees, right?
That is what the commission charges statewide candidates who either fail to file or late file their personal financial disclosure statements across the board.
Okay. That's all.
Can you break it down for us?
There's a statutory $125 late fee for every office in the state from dog catcher to governor. That is the statutory fee. There is a civil penalty that is $1,000 for a statewide candidate that we charge to.
The $1,000 is the maximum for each violation of the Campaign Finance Act, though, right? There's not, or is there specifically something in the act that says $1,000 for statewide?
There is not anything in the act. It is what our commission, our staff charges all statewide candidates. I think there are 7 of them. The governor, lieutenant governor, and the statewide commissioners are the only statewide candidates.
But to be clear, today, we're only here to determine if there are reasonable, if there's reasonable suspicion or reasonable cause to believe that the Campaign Finance Act has been violated. We're not here to, issue any fines to anyone. It's going to be referred to OSA for that, so we don't really need to get into the, the deep, dark, dirty water regarding, what the amount of the fine would be necessarily.
But I think that's the reason why Mr. Dean's here.
I understand that that's going to be something that I just want to make sure that he understands that we're not here today to actually determine the amount of a fine. It's just whether the act was violated.
Commissioner Hicks.
So I'm pretty focused on being consistent. Seems like I've seen, like, maybe not the last one, but the one before that, we fined only $600 or $500. That seems like $625 is what I remember when candidates fail to do something.
That was not a statewide candidate. That was,
I remember Derek Jackson. I think he had $625.
Robert, I've got this. So this, for the record, and as manner of refreshment, the law changed after the latest legislative session regarding statewide partisan candidates for office, and it enhanced the disclosure report. And you'll recall that I actually personally emailed every single candidate and reminded them of the enhanced requirements
For the person.
for the personal. What we've done in all of those cases that have come before this commission is, for the people who did file it but failed to include all of the relevant information, they were assessed a $125 fine per section they omitted. And almost all of them ended up being the $625 you're referencing. For the individuals who just didn't file it at all, once they rectified that and did file it, they were assessed a fine for $1,000 for not filing anything, and then the late fee once they became compliant. And we did that in each of those relevant cases as well.
But aren't we also alleging I'm sorry, Mr. Chairman.
Go ahead.
Are we also alleging that he didn't file his campaign disclosure?
No, I think Mr. Pruitt indicated we don't actually have evidence that he raised or spent money. So we didn't allege,
So is it the staff's position that if you don't raise or spend money, that you don't have to file DOI?
correct,
Because we changed that the qualifying fee
To
was
be
no
paid
longer
personally.
a contribution.
correct.
It's hard to tell whether he's agreeing with that.
Well, you know,
I can't disagree. It is what it is.
it is interesting though, because we've had a few candidates, particularly for, over the last few cycles for state house and state senate, say, listen, I want to sign up and put my name on a ballot, but I don't intend to do anything.
Yeah.
I don't want to avail myself of this process. If I tell you I'm not going to raise or spend any money, I'm just going to maybe knock doors, maybe not. And our answer has consistently been, if you don't raise or spend any money and you pay out of pocket for the qualifying fee, you don't have to file the DOI reports.
For the commissioner's edification, it's 21.530 subsection G, which triggers filing reports for the CCDR. That's the requirement that you file a DOI before you accept or expend campaign contributions. If you do not elect to do that and you do not file a DOI, you have no CCDR reporting requirements.
But the alleged violation here is 21,550.
Correct, which is related to the PFDS, which is triggered by a separate code section which states you must file after qualification, which he did qualify.
I got you. Okay. Anything else, Mr. Brewer?
Yes, sir.
Okay. Oh,
This is from my edification, but something that you mentioned, so that when this goes to OSA, they will determine the fine amount?
They recommend that.
They recommend a fine amount in their initial decision that then can either be accepted by law or this body can reject or amend.
Us.
Correct.
Right, so, I mean, I guess in essence, I understand that it's a preliminary.
It's the issue is
Recommendation.
procedural. I get where you're going.
Well, I mean,
But it's-
so we can have, I mean, and I'm, Mr. Dean, I'm sorry I'm having this discussion in the middle of this, but because I think you should be heard, but it's basically a recommendation from the staff that ultimately, after it winds through OSA and comes back to us, will either be accepted or modified.
But the way that I look at it, it's going to be the staff's recommendation before the administrative law judge, the Office of State Administrative Hearings. And then when the decision comes back to us, we either, don't act on it, which makes it approved by us, or we have the opportunity to overturn it and impose a different fine.
Right.
So I still don't think the question's appropriate for us right now to determine what the amount of the fine will be.
It's a procedural issue, and I think I understand what Commissioner Thompson and Watts is saying. We all agree on the violation, including the respondent. It's about what is the appropriate remedy.
The only reason,
I mean, it's liability versus damages
It is.
in my world.
Yeah.
Yeah,
Yeah,
okay.
you're right.
Yeah, okay. I get it.
Mr. Dean, would you mind stepping over to the podium, because we need to make sure that we can hear you.
All right, I got the charge. He said I didn't file a statement. I did file a statement. I didn't do it because I didn't know about it. I didn't read it. And, but I before I did it, but I sent a disclosure back on 25th. I got a receipt here for it, but April, wait a minute. Yes, April 26th.
And what are you speaking of that you filed on April 26th, or you submitted on April 26th?
It was was that financial disclosure, the financial disclosure.
I don't know what form you've got there, if you want to show it to some members.
Well, the form, after they sent me here, yeah, it's a personal, this is just a letter, but this is not it.
Okay.
I did it on online, I made a copy online and I saved it to my computer, but it turned out that the form that I did was a temporary file and it expired, so I don't have a copy of it. But I do have, what I have here is a copy of the cover page I sent with it to this office, first class mail, and the receipt. But, like I say,
Can you show the staff the receipt?
yes. Yeah, the receipt.
So did you print it off on like a website and then fill it out by hand?
No, I typed it, I filled it online. It stayed here on the 22nd, sent to, this zip code right there. And then, here, on the 26th, and the letter is on the 25th. I covered it.
So one of the problems here is we don't accept it online if you file it through a report. So that's.
Online, it says always, the statute specifically says send it, certified mail return receipt requested. Yeah, here it is, I got that. Let's see, let's go to the receipt. Yeah. The candidates. All right, what is it? Yes, it is. Here it is,
So you're correct.
yeah, no, see right here?
All statewide elected officials and members.
Yeah, well, that, that doesn't apply to me. I'm not an elected official. Yeah. No, it says right here, the county committee, however,
Yeah.
however, if the report requested was
Robert,
not filed,
Mr. Cusack, y'all, you hold 1 minute.
Do you know the code section that requires the form to be filed electronically?
I believe it is contained in 2156.
what if there's no, what if we don't have no electronic?
Just a second, sir. But there is a requirement
Yes.
in the statute, we're having that discussion. So
It says here, electronic filing is not sufficient. But anyway, I sent one, and I sent it's supposed to send back a report of being late and the late fees charged with the schedule. And they didn't do that. So, I mean, I don't know why they call it here instead of doing that, but.
Commissioner Thompson, go ahead.
Sir, did you file the report electronically, or are you saying you filed it via mail?
I said filed it by mail,
You filed it by mail, not electronically.
not electronic.
If, Mr. Lane, you're saying the code, there is a code section that requires it, so even if we do not dispute that he mailed it, it still does not comply with the Campaign Finance Act, because the Campaign Finance Act requires it to be filed electronically. Is that the staff's position?
Yes, Commissioner, you are correct. And as far as our practice, when we receive mail filings, we keep a copy of it and we return a notice to the person who mailed the filing stating that the law requires electronic filing with further instructions on how they register in the electronic system and how they file electronically. That by law, we are not allowed to accept paper filing.
Okay, I don't know anything about it, but it says here, it says, except when electronic filing is required, the mailing of a notarized financial disclosure statement by U.S. mail with adequate postage affixed with the required filing time as determined by the post office shall be evidence of filing, so.
And
So
it's-
that, okay, let's, hold on, because I want to be really clear, I'm going to give you time to do it. 2156 doesn't say what I think you think it says. And I
Although
don't
that might be,
on the
me
spot.
talking, that might be
Hold on,
talking.
Mr. Dean,
about-
please wait a second. I think that he's trying to make this clear.
Yeah, so I'm going to give everybody a minute. I'd like to see that section, whatever it is, and that's, I'm sure it says that you say it says, but I'd like to see it. Mr. Dean, I think what you're reading from has to do with legal filings in court.
No, this is, I'm reading
This is the same, this is in the
21.5.
same,
Please wait 1 second. Let Commissioner Watts finish, okay?
He's reading from 21.534, but there are two parts of 21.534. There's one that deals with statewide and state level candidates, so your constitutional officers and House and Senate. There's a second subsection that was entered in 2014 that deals with county and municipal officials. So when it says that you can mail a notarized copy in or use electronic filing, that part of the code section is referring to city officials and county officials who do not file directly with us.
It's 21,550D.
Correct, thank you.
21,550?
D.
And then there'll be a mirrored provision contained in 21.534 for the CCDR. But since we're dealing with PFDS, you'll want to do 50D.
Okay, that's it, 21,550D, that's it. What, I just want to know, what did you find, Mr. Cusack, that the mailing information that he had showed?
It just shows that there was something mailed to our office, but it's our.
Tell me what it showed. Well, I want to know, or bring me the receipt, I want to see what
Yeah,
it was.
it's just a receipt.
Well, it's a receipt, it just shows the date it was sent and the time and,
Do you mind if we look at it?
yes. And like I say, I had the cover page, but I don't have the temporary file.
You're talking about 50?
Well, sure, I've written one.
Y'all want to see this? For any reason? Does the staff have any record of having received that by mail?
I'm searching
Okay.
the drive right now, and the only thing I see is this case, the case number.
And what's the procedure of the staff, if I may ask?
No, go ahead, yeah.
What's the procedure of the staff when you receive a paper filing?
We have a dedicated staff member, Ms. Rochelle Wilson. She takes the filing, she reviews it, we have a staff member, they review the filing, they confirm what level of office they're running for. If it's a local or a city office, we forward the paper filing after we keep a copy of it to the local or city official who maintains the records, because that's their job. For statewide officials, we send that person a notice saying, we have received your filing, but lawfully we cannot accept it. We cite for them the code section, quote the code section, and then provide them instructions on how to register in our system and properly file. But we're very clear that your paper filing does not constitute filing with our office.
What do y'all do about the deadline at that point? Do you extend the deadline or anything? Do you or what?
We don't extend the deadline, it's considered late, but they don't get punished for non-filing.
Mr. Watts?
Okay, I was processing that last point. So remind me that there's the late filing issue that we're having here, and then what are the other violations?
That's the only actual violation we're alleging, is that the PFDS was not filed.
Right.
And as a, and Mr. Dean has
Not filed, I'm
spoken.
sorry.
Can't be late until it's filed.
Right.
Yeah.
The only violation is 50A1.
But, okay, just so I'm clear, the mailing and the receipt issue, I guess that would be the only filing, so there is no late filing because there's no filing, that's what you're saying, but, so there's a dispute as to whether it was mailed versus electronically, and Mr. Dean, I think you attempted to file it electronically and then something occurred with your computer?
Well, I didn't have a means to file it, I don't know how to do that.
But you said you saved something locally to your computer.
There was forms. I think I got an email from the party, from the Democratic office prior to qualifying. And I saved that, and I think that there was a form inside of that, of the email that she sent me out.
I think what he's saying is that he downloaded a PDF, filled it out, and then, are you saying you
Yeah,
printed it?
I was trying, I made print it down and had it notarized and send it here. But, and I saved the filled
PDF,
form,
but it's saved
on the-
as
on
a
the
blank
computer.
template.
but it expired temporary.
Still not filed. What he's basically saying is he did a template, saved it as a PDF, but it's saved as he filled it out, saved
happened
it,
to everybody.
and then it's saved as a template.
Well, and
I mean, it
Commissioners,
was blank.
the enhanced PFDS that went live this year is not available in a PDF template download. You have to register in our system in order to access it. The only downloadable template is an example template where it's filled in showing you how to fill in the enhanced section. So even if you found a template, he's not using a correct PFDS template because it's not accessible.
So you're saying what Commissioner Hicks is talking about, that can't happen?
Correct.
Well, couldn't you gotten it from the party?
Yeah, that,
And the party could have given him.
We didn't provide a,
No, I
It would have been
know. I think that's
right. You may not have provided it, but the party may have provided a template.
maybe.
Maybe, but your point is, it's not the one that you use, or you
Correct.
can't use a template, first of all, but I got
when
it.
was the deadline?
But he still could be right, even though he may have still
Correct.
violated the code.
You are correct, Commissioner.
A month before
When
that.
was that?
It's in March.
Yes, 7 days after qualifying.
So he qualified on the 7th, so it would have been the 14th or
Correct.
15th
Of March.
of March.
And you attempted to send this in on, or the receipt
Yes,
says April 26th.
actually, I actually had someone to call, from this office, sent a, email requesting that I file that, because they say they hadn't received it. And I went
Where is
on,
that?
searched around and found, remembered that I maybe had a form, because,
Is that what Mr. Baywell
he sent
filed?
me out that information, before, I qualified, but, so I went in, I sent it in following the email I received, but the email got, deleted too, so I don't know.
Okay, that was clarified, that was actually after that was after the commission filed the complaint in this case.
But why,
Is it?
why don't,
Oh, yeah, no, it should have followed. It should have followed,
That's what I
because,
said, after.
well,
yeah,
that's another.
no, they filed a complaint after I did that,
Oh,
because,
Hold on, just hold on, and this is for the staff, because y'all apparently
wait a
have,
second, please.
so y'all apparently have the email record. So you filed a complaint and then emailed him, Mr. Dean, to ask him to file the submission?
If I may, after the complaint was filed, Mr. Baywell, who can't be here today, is one of our staff attorneys who handled this case, got in touch with Mr. Dean about how to file, how to register on the civic system and file the PFDS electronically as is required.
That's after the complaint was
That was
filed?
after the complaint was
Why
filed.
would you do that?
Because the
Not you, but hypothetically speaking, why would one do that?
Because there's still a requirement that be filed as a statewide candidate.
Understandably, but we've already proceeded in the process of prosecuting the infraction.
One of the reasons that we reach out to people to have them do their filings is because it's almost a road standard. In every complaint we file is that we ask that this commission order people to amend their reports or file outstanding reports for the purpose of transparency and disclosure, which is the primary purpose of the commission.
Yeah, I don't necessarily have a problem with that.
And we are looking through the server now, Mr. Cusack's looking, we do not show a record of him sending in by mail his PFDS filing. Because we would have kept a copy along with the, hey, sorry, but we can't take this, please do X, Y, and Z, which if you mailed it in April, I would assume would have come sometime in April. We're not showing a record of us receiving it.
Yeah, well, someone who said I told them I sent it, they said they don't receive it. If it's not electronic, they don't electronically file, they don't receive it. So, I don't know, they could have thrown that away since they got here, I don't know.
Well, that, I mean, I hear you, but that's, I mean, we have a process to receive mail at the staff level. Okay.
Now, as far as how we got the case, if that's one of the questions, what happened is we pulled everyone who qualified for a statewide office to see if they filed a TFDS. We did not rely on whether they filed a template or not. We simply looked at who qualified, and then once we had that list, it was did they file?
Commissioner Johnson?
I think we're going down, I think we just need to get back to the facts. And I don't want to cut Mr. Dean off. I don't mind cutting staff off, but I don't want to cut Mr. Dean off. But, I mean, there's no dispute you did not file electronically. Okay? You sent one in the mail. Let's just say that
I
happened.
didn't file electronically, I don't know any, I didn't know anything about the requirement.
All right. I don't know what more we can do, because all we're doing is trying to, if this is a preliminary hearing, well, that's all we can do. I mean, unless, he'll have 30 days to work with staff. So I make a motion that we find reasonable grounds that the Campaign Finance Act has been violated because the personal financial disclosure was not filed electronically.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, motion carries. Mr. Dean, the matter will be in 30 days. It'll be referred to the Office of State Administrative Hearings in the event that y'all aren't able to get something worked out between then. I would recommend that you continue your dialogue with the office and try to get this matter worked out, with the staff before the matter gets referred over to the Office of State Administrative Hearings, because it'll go over there before an administrative law judge to have a formal hearing, okay? All right. Thank you very much for coming today.
All right, thank you.
All right, that takes care of all of the preliminary hearings. Is everybody okay continuing on right now? All right. I liked the way, I don't know if the other commissioners agree, but I liked the way that we handled the consent orders last time, which is that we heard all of the consent orders and then voted on them one time.
But what we didn't do was get a long dialogue on it. We just
That's right.
summarized the case real quickly.
Right.
And then we voted on all of them.
Second.
There was something.
We're going to refer to, I used to always remind Chairman Evans about, we don't take any action, on the administrative dismissals. That was always, what my claim to fame was on the commission. And we're going to refer to, how we handle the consent orders now as the Commissioner Hicks rule. So this is how we're going to handle this, staff. We're going to take these consent orders under the Commissioner Hicks rules, and so we're going to hear all of the consent orders. I want you to announce the case. I want you to give us the Cliff Notes version of the case, and then we will vote on all of those at one time at the completion of all of the cases.
Mr. Cusack, the longer you talk with the questions, you could get. So,
Mr. Amati wants to say something first.
Mr. Cusack, I know there were indications that one or possibly two individuals would be attending via Zoom. And I believe at least one of those was a consent order. Is there anyone present on Zoom that would potentially want to address this commission in your consent orders before we go through them all in a block?
If so, let's do those first, certainly. That's a good
Yes,
point.
and not right now. I know Ms. Taylor, the first one, I just sent her an email saying we're about to hear her case, but she just wanted to, I think, just tell her thanks to the commission. That's what I understand. I know Ms. Wagner is here on behalf of the committee of East Cobb. She represented them. And then I believe it was Ms. Jackson on, and Mr. Dreyer is here for Ms. Thomas. Ms. Thomas is here as well. And then Ms. Jackson, I know, is joining via Zoom.
All right, so is Ms. Taylor going to be here? Because I want to go ahead and mark these, because we're going to do them in that order. Of whoever's here or on Zoom, we're going to do those first.
Yeah, she's not, there's no one in the Zoom waiting room right now.
Okay, so let's start with then, I'm going to go ahead and,
Can I just make one comment?
Sure.
And the premise is, obviously, the folks that are here that want to speak and want to give their thanks, they should be able to do that.
Absolutely.
If they're just here to listen, they don't have to do that.
Right, totally optional. It's an option, yes.
Thank you.
all right. So I want you to call the cases first, where you know someone is present, and we're gonna handle those first, and we'll find out if anyone wants to speak. You don't have to respond, okay?
So do you want me to jump around this?
Yes.
Okay.
But I want you to announce what letter we're on for the folks that you know that are present.
Okay, I will start with the first one where I know somebody is present, that's letter B, and
Okay.
that's in the matter of Committee for East Cobb. And Ms. Wagner is here, she represented them along with Mr. Chalmers in that matter. So that case is the Committee for City Hood and East Cobb Incorporated and Craig Chapin. It's cases number 22-0074-C and 22-0088-C. This was a ballot committee that should have registered and advocated in the primary election on the question of whether East Cobb would incorporate as a city. So there was the vote yes part, vote no part. They were on the side of the vote yes part. This committee, or I believe it was actually a C4, had been advocating to get this question on the ballot for a couple of years now. And so ultimately, during the General Assembly session this year, House Bill 841, which was signed on February 17th, put this question on the ballot for the primary voters. Now, from that point forward, when this question is on the ballot, that's when a ballot committee would have to register, once that question is slated to appear on a ballot. So they didn't have to register prior to that, but once this question is signed and put onto a ballot, that is when a ballot committee, subject to meeting that $500 threshold of contributions or expenditures, has to register and then report CCDR 15 days prior to the election. In that case, in regards to this group, that did not occur. They did not register. There was 2 cases that were filed. One was sua sponte by the commission, and then another came in on a third-party complaint. And ultimately, upon being served this complaint, they went to Mr. Chalmers and Mrs. Wagner and were given the advice that, yes, you had to register and you didn't do so. There was a mitigation in speaking to them. They relied on another attorney's, I guess, legal advice, which ended up being wrong. And so they didn't register based upon that advice. It doesn't seem to be they were trying to subvert registration or trying to not register and disclose. They were ultimately got some bad legal advice. So in this case, Ms. Wagner and Mr. Chalmers immediately got me any document I requested, very cooperative with the commission, and we were able to bring this matter to a close very, very quickly. They are paying a $5,000 civil penalty and late fee in this matter for the failure to register, the failure to file the CCDRs, and those will be filed within 30 days of the acceptance of this order.
Ms. Wagner, do you have anything you want to add?
As I said, I'm Heather Wagner from Chalmers and Adams, representing respondents, and just here, he adequately summarized it, and thanks for working with us. It was a pleasure, and we're happy to get this resolved.
Okay. Well, thanks for coming.
You're welcome.
All right. Is that the way we're going to do it? Okay. All right. I didn't know if we were going to have a special vote on the folks that were here first.
Yeah, I have a question.
Yes. Go ahead.
And this is more for the commission.
I was gonna say you spoke too long, you got a question?
Right. Any more for the commission, you did speak too long. But anyway, in the past, I feel like we had this discussion the last time, that we did not accept a consent order because the actual documents were not filed yet. Did I make this up? Did we?
No, I don't think you made it up. When you say you used to file, you just mean not completed yet? Or
Right,
it's
the
not?
form, yeah, the disclosure reports have not been filed. And when we talked about it the last time or 2 times ago, we said, well, wait, we're not going to agree to something if the things have not been filed. Is that the other commissioner's understanding?
I
think-
thought you were talking about something else.
Okay.
I think if the consent order was something still left that's contingent is fine.
Okay.
Yeah, I think it.
I think that was just on the PFDSs.
No, it also came up in the case of a former mayor who we also didn't have certain bank records.
Oh, okay.
Whereas here they've provided
That's
us,
what we were waiting on that.
they've provided us everything here.
I just want to be consistent.
No, yeah, that's actually a good point too. Okay, next case.
All right, I'm going to skip around to matter D, and that's in the matter of Erica Thomas. And Mr. Dryer and Ms. Thomas are here for that matter. In this case, some of the commissioners I know were on the commission then. This case had been transferred, or was going through the Office of State Administrative Hearings process. So it's actually, in the matter of Erica Thomas, just to get the case style on the record, 2018-0056 and 2019-0031. There was a preliminary hearing that was held, I believe in 2019 on this case. So this case had to do with a failure to file personal financial disclosure statements and campaign contribution disclosure reports. I believe there was 7 missing reports and 4 late filed reports, and then 4 PFDSs that were not filed. That was done in 2019, this commission heard, and then it was put in motion at the Office of State Administrative Hearings. And prior to our hearing on that, we've reached this consent order. So what has happened now is Ms. Thomas has filed every single missing report, and that even involved going back, opening up our old system so she could file those reports. So those reports are now filed. Everything going forward has been filed. Mr. Dryer, Mr. Berry, and Mr. Siegelman represented her in this matter, very responsive. There was a lot of back and forth of what the documents and everything to get those filings done. So they've been very responsive in getting commission staff everything they needed to sort of close this case out. There was she's agreed to pay a $10,000 civil penalty in this matter on top of, and that includes, the breakdown is $1,875 in late fees and then $8,125 in a civil penalty. There were some interesting issues that arose when this case started, because it started back in 2019 and then COVID happened, and so there was some sort of dropped off the map, and ultimately the communication wasn't great. I know Mr. Dryer can sort of speak to that, but we were able to come together. They got us all the documents we need, and so that's how we're wrapping up this matter.
Mr. Dryer, Ms. Thomas, do you have anything you want to add this morning?
We just want to add that we really do appreciate working with the attorneys at the commission and attorney for the Attorney General's office. Yeah, the point I want to stress is we did miss a preliminary hearing. There was absolutely no intent. There was a lawyer of record at the time, did not get notice of that. But I tell you, Representative Thomas, certainly myself, respect the role of this commission. We worked as hard as we could to get this resolved. Representative Thomas is going out of pocket significantly with this to clear this up. Just wants to show that, you know, we respect the job that y'all do, and we worked in good faith as best we could try to get this resolved. So we think this is fair, and we appreciate it.
Mr. Dryer, I'll tell you, and I didn't say this with Ms. Wagner, but again, to hear both, with respect to both of you, that Mr. Cusack saying that, you know, you guys were very responsive, anything that he asked for, you know, that y'all provided it to him, those are the kind of things that we like to hear. So again, we appreciate all the assistance that you've given to the staff in trying to get these resolved as well.
My pleasure. Thank you.
Thank you also for coming this morning. Anything further on that one? Mr. Cusack?
No.
All right. Which one are you going to go to next?
And I understand Ms. Taylor is joining us via Zoom now,
Okay.
so that's going to be A.
Hold on. No.
Right. And this one is in the matter of Dr. Candace Taylor, 22-0036-C. As we dealt with earlier, this is just a PFDS case that was on the enhanced statewide disclosure. Ms. Taylor filed her PFDS, but ultimately didn't include those calendar years which were required of the income. We had a preliminary hearing on it last time. She immediately reached out to our office, agreed to this consent order, and paid that day of that hearing. So she was very responsive, and then amended that hearing, or amended the PFDS to include those calendar years of income. So she's been very responsive and is paying a $625 civil penalty for not including those years of income.
Ms. Taylor, can you hear us?
I can.
Okay. Do you have anything that you would like to add to Mr. Cusack's statement regarding the consent order? She appears to be.
But I can meeting hearing. I thought that I already submitted everything, and I had submitted the same amount to another filing, and it was actually, I got more insurance. So I came, and I did immediately get everything turned in, and I so apologize for not being here, but my family was up all night long, and it was a really rough night, and so I would have been here otherwise. I thought I had everything taken care of, but I had a rough day that day. So anyway, it's all submitted, and I'm sorry about that confusion.
Well, we thank you very much for Ms. Taylor for being here this morning. We couldn't hear everything that you said due to some technology issues, but it sounded like we understand now why you weren't present for that preliminary hearing. We appreciate everything that you've done to work with the staff to get this concluded. And again, thanks for being here with us this morning, okay?
Thank y'all. Thank y'all for taking care of that.
Okay. Next case.
The next case is going to be letter C. It's 22-0073-C. It's in the matter of advocacy for action. This was a group that should have registered as an independent committee that sent out a communication, an express advocacy communication during the judicial elections during the primary on May 24th of this year in Fulton County and advocated for the election of a judge. We received a text message that showed the express advocacy. They were very responsive, got me the records we needed that showed their the money that was spent on this text message, and they've agreed to pay a $1,000 fine and a totaling $875 in a civil penalty and then $125 in a late fee for failure to file and register with the commission. And then the next and the last case I have is in the matter, it's letter E, 2018-0126, in the matter of Allison Feliciano. This was another case which was in the OSA pipeline in which we have reached a consent order with her. Ms. Feliciano ran for Georgia House, District 19, in 2 election cycles, and raised a grand total of $500 during that whole time, during that whole period. She missed a lot of filings. It was pretty apparent that she had no idea what she was doing when it came to the filings that she was supposed to file. And we've all agreed with her to a $500 civil penalty. And the only reason we did that is because of the amount raised by her was pretty insignificant, but also there are some financial difficulties she's having that we were able to speak to her about. So she's on a payment plan to actually pay that off. So I believe it's a deviation in the sense that it's a low fine amount for the amount of filings that she missed. However, based on the income, based on the amount of money she raised, I think it's appropriate in this matter.
I recall hearing about this, it was been years ago. I haven't heard about it very much recently, but, folks filing for the hardship waivers. I'm not dreaming that, am I, Mr. Lane?
You're not.
No.
You're not
Okay.
dreaming.
Was this handled under that framework or no?
We can actually sort of, based on what I'd be comfortable presenting to the commission, if I can make that representation, we won't make them fill out a hardship waiver if I can sort of see the documentation behind it and talk to them. Now, that would be more appropriate when they have late fees. So they submit a hardship waiver when they have late fees saying, I can't pay this due to a financial hardship or lobbyist fees as well. Here's my hardship, and then we can take a look at it and make a determination.
Okay.
Mr. Cusack has received a lot of questions, meaning he's violated the Hicks rule.
Well, it looks like he's done. Mr. Lane, are you next?
And I will do my best to comply with the Hicks rule and the Watts rule. Commissioners, the first case is in the matter of Michaela Brockington, case number 22-0030-C. Respondent ran for State House District 169, filed her DOI on March 25th, 2022. The parties have agreed that respondent late filed her calendar year 2021 PFDS, late filed her campaign contribution disclosure report for April 30th, 2022 and June 30th, 2022, so 3 violations. She's agreed to pay a late fee in the amount of $375, a civil penalty in the amount of $375, total fees being $750, She is on a payment plan, with final payment plan becoming due on March 1st, 2023. The second case is in the matter of Mr. Jaha Howard, case number 22-0058-C. In that case, respondent qualified to run for state school superintendent on March 7th, 2022. The parties have agreed that he failed to file, he late filed his enhanced personal financial disclosure statement and has agreed to pay a late fee in the amount of $125 and a civil penalty in the amount of $1,000. Total fines and fees, $1,125 due within 30 days from the date the commission enters its order. The next case is in the matter of Kelly Rose Aldifer, case number 22-0008-C. In that case, respondent ran for State Senate District 16, filed her declaration of intent on May 17th, 2019. She was unsuccessful in her election. The parties have agreed that her only violation is a late filed campaign contribution disclosure report for December 31st, 2021. The parties have agreed to the payment of a $125 late fee and a $125 civil penalty, $250 due and payable within 30 days from the date of the commission's order. For case number 22-0011-C in the matter of Ms. Sonia Jackson, Ms. Jackson ran for the Chatham County Tax Commissioner, filing her DOI on March 16th, 2020. The parties have agreed that respondent accepted impermissibly $1,700 before the filing of her declaration of intention, that she late filed her campaign contribution disclosure reports for September 30th, 2020 and October 25, 2020, and that she late filed her personal financial disclosure statement for calendar year 2020. The parties have agreed to the payment of a $375 late fee and an $875 civil penalty. Total fees due within 30 days, $1,250. In the next case, in the matter of Kenneth Adams, case number 22-0009-C, respondent ran for the Chatham County Commission District 8 seat, filing his DOI on March 9th, 2020. In that case, the parties have agreed that respondent did not file his campaign contribution disclosure reports for September 30th, 2020, October 25, 2020, December 31, 2020, June 30th, 2021, and December 31, 2021, and that he did not file his personal financial disclosure statement for calendar year 2020. The parties have agreed to late filing fees in the amount of $500 and a civil penalty in the amount of $700, $1,200 due and payable pursuant to a payment plan due to financial hardship, due and payable on August 1st, 2023. In the next case, in the matter of Mr. Aaron Whitley, case number 22-0014-C, the respondent ran for Chatham County Commission District number 6, filing his DOI on December 12th, 2019. The parties have agreed that the respondent late filed his campaign contribution disclosure reports for December 31, 2019, January 31st, 2020, April 30th, 2022, 2020, June 30th, 2020, October 25, 2020, and December 31, 2020. Total late fees agreed upon $750, a civil penalty in the amount of $625. Total fines and fees due by February 1st, 2023 in the amount of $1,375. In the matter of Mr. Luke Martin, case number 22-0024-C, respondent ran for the State Senate District 52 seat, filing his DOI on March 25th, 2020. The parties agreed to 2 separate violations of accepting contributions prior to the filing of the declaration of intent. The parties further stipulate and agree to the payment of a civil penalty in the amount of $4,000, the $4,000 to be due within 60 days from the entry of the commission's order. In the matter of Mr. David Bell Isle, case number 22-0034-C, respondent ran for the Secretary of State position, filing his DOI on March 7th, 2022. In that case, the parties agree that respondent failed to disclose his income on the enhanced personal financial disclosure statement for calendar years 2017, 2018, 2019, 2020, and the first quarter of 2021. There are no late fees associated with this filing because it was filed, it was just incomplete, and parties have agreed to a civil penalty in the amount of $625. That's $625 due within 30 days from the commission's order.
Mr. Lane,
Yes, sir.
sorry to interrupt you. Will you back up, please, to L? What was the fine?
For L, in the matter of Mr. Luke Martin, the fine is $4,000 civil penalty.
Thank you. Sorry, go ahead.
No, you're good. In the matter of Mr. Todd Levent, case number 22-0072-C. In that case, respondent ran for the Forsyth County Commission District Number 3 seat, filing his DOI on March 1st, 2018. The parties have agreed that the respondent did not file his calendar year 2021 personal financial disclosure statement and failed to report $625 in expenditures on his January campaign contribution disclosure report for 2022, and failed to disclose expenditures in the amount of $1,102.43 on his his April 2022 CCDR. The parties have agreed to late fees in the amount of $125 and civil penalties in the amount of $375, $500 total penalties due and payable within 30 days. In the matter of Mr. Larry Rivers, case number 22-0012-C, Mr. Rivers ran for the Chatham County Commission District Number 2 seat, filing his DOI on September 12th, 2019. The parties have agreed that Mr. Rivers late filed his campaign contribution disclosure reports for December 31st, 2019, January 31st, 2020, April 30th, 2020, June 30th, 2020, September 30th, 2020, October 25, 2020, and December 31st, 2020. Respondent further agrees that he failed to report 23 contribution transactions in the amount of $5,987.64, and then failed to report 77 expenditures in the aggregate amount of $5,496.38. Total late fees amount to $750, a civil penalty in the amount of $1,975. Total penalties to be paid by payment plan due and payable by September 1st, 2023.
Total again?
I cannot trust my math. $2,725.
Thanks.
For Mr. James Jones, case number 22-0100-C. Mr. Jones ran for State Senate District 1, filing his DOI qualifying for office on March 3rd, or March 11th, 2022. He late filed his PFDS for calendar year 2021. A late fee was imposed of $125, and he has agreed to a civil penalty in the amount of $125. $250 in total penalties due within 30 days of the Commission's order. And then the final consent order case in the matter of Mr. Rashid Malik, or at least my final consent order, case number 2022-0043-C. Mr. Malik ran for the Lieutenant Governor's seat, filing his DOI on March 26, 2022. He qualified for office on March 7, 2022. The parties have agreed that respondent late filed his PFDS for calendar year 2021, that he late filed his CCDR for April 30th, 2022, and that he late filed his CCDR for June 30th, 2022. The parties have agreed to payment of $375 in late fees, $850 in civil penalty, total fees due of $1,225 due and payable within 30 days.
Thank you, Mr. Lane. Mr. Pruitt? I think you just have one case, is that right?
Just the one, case number 22-0107C, in the matter of Martin Lewis Carty and the committee to elect Lewis Carty. Mr. Carty ran for APS Board of Education District 3 in 2017. He late filed his December CCDR, and there were some oddities about personal loans that were made to the campaign. As soon as he got the complaint, he got in touch with us, sent us all of his records about the financial details of the campaign, and it was clear that there was no malfeasance or anything, so he agreed to pay the $125 late fee for the late filing and the $125 civil penalty for the late filing, and has already sent that check in.
Total fine?
$250.
And those were for violations in 2017?
Yep.
Why were those just coming up now?
Because we have been doing a review of the Atlanta Public Schools Board of Education campaigns, and so we've just been going through a lot of those.
Okay. That's the end of the reports on the consent orders. Commissioner Hicks, do you have a motion?
Mr. Chairman, I move that we accept the consent order as presented.
Do I have a second?
Second.
Got a motion and a second. Any discussion?
Well done, staff.
All in favor say aye. Aye. Any opposed? Motion carries. All right, we'll move to item 5 on the agenda. Mr. Amati, are you handling the administrative dismissals? Oh, no, you're not. I'm sorry. Why was I thinking that you? I don't know. Sorry.
That report's coming, you guys. So we got-
No, you hold on. All right, hold on.
I don't think that's happening today. Anyway, all right. Anyway, the administrative dismissals.
For these, it's just, the question is, do any of the commissioners who have questions haven't reviewed it? If not, then we move on.
We just go.
We're not even going to hear it in the portal.
We had it for a while.
Okay.
Thompson.
Yeah, we have it for a while. No, that was a Hicks rule.
That was-
That's his initial rule.
No, well, I'm making the consent orders the Hicks rule. I'm writing this down, and I'm going to make the administrative dismissals now. It's not the Cranville rule anymore. It is now the Thompson rule.
Because the administrative dismissals are dismissed by operation of law when I sign them.
Right.
So unless the commissioner has a question,
All right.
petition to reopen it, we just move on.
Well, then I'm still going to call that item on the agenda, number 5, administrative dismissals. Are there any questions or comments to be raised by any of the individual commissioners regarding the administrative dismissals listed on the agenda? Hearing none, we will move to item 6 on the agenda, which is, it might be a report of the executive director. Mr. Amati?
You know, this is our third meeting together in like 60 days, and I thought, I have nothing new to give. But then Mr. Watts has to make a big deal about it. So now I think I want to talk about budgets and financial collections. No, I don't have anything to add, Mr. Chairman.
Thank you, Mr. Amati. Next item on the agenda is the report of the Attorney General's office. Ms. Young, do you have anything for us today?
Just a couple of quick things. In the
Wait a
past-
second. I don't know which number you are, sorry.
Well,
They even gave me the cheat sheet today. And, sorry, I missed it. Go
um,
ahead.
the most major developments have been the 2 new lawsuits that we have received in the past couple of weeks, both of which have motions for preliminary injunction pending, and our responses to both of those are due tomorrow. So we have drafts of those responses in the works, and we'll timely file responses to those motions on behalf of the commission by close of business tomorrow. First action is the Libertarian Party of Georgia and its candidate for Lieutenant Governor, Ryan Graham, who has filed a lawsuit very similar to the one that was filed, the ones that were filed by Senator Deidre Perdue and by Stacey Abrams, challenging the Leadership Committee statute, saying that basically the Libertarian candidate cannot have a leadership committee, whereas the Republican candidate for Lieutenant Governor Burt Jones has formed a leadership committee and raised, I think, $60,000 that he would not have been able to raise under typical campaign finance limits. That case was actually brought against the commission itself, and the individual commissioners were not named, as is the typical process for the ex parte Young exception to the 11th Amendment. The commission, as an agency of the state, cannot be sued directly, which is why y'all as commissioners get the pleasure of seeing your names as defendants in your official capacities, usually in these federal lawsuits. So that will be part of our response is that the commission itself is not a defendant that can be sued. I will advise that typically judges are fairly liberal about allowing amendments in cases like that, so that may be a situation that gets corrected by the plaintiff's counsel down the road. Also, you may recall in the Purdue and Abrams cases, the judge had said that the commissioners themselves were also not the proper defendants to be restrained or enjoined from operation of the statute, that it was a leadership committee that needed to be brought in as a defendant, and the plaintiffs, again, did not name the leadership committee as a defendant. So based on what this judge, who is the same judge that adjudicated the Purdue and Abrams cases, we have every reason to anticipate a similar result. The second federal lawsuit that we have received.
Can I ask you, is it Judge Cohen?
Yes.
Who did, okay. And then, so, as I understand it, you're going to seek to dismiss the commission as a party.
I don't. This is just where I was going to get concerned about some of this. You know, we can add that on the agenda to executive session if we want to. I don't want to get into, I guess,
strategy.
Yeah, the strategy behind how we may handle the lawsuits or something like that. I think that's more appropriate for her to discuss with us in the executive session.
Certainly.
Here I get reprimanded about attorney-client.
And I will just state that, you know, we're not making any secret of the fact that we'll be raising the 11th Amendment bar in any public pleadings that will be filed tomorrow. So that is, you know, not a matter of privilege, but any strategic decisions, you're correct, should be discussed in an executive session. The second lawsuit, which you're aware of, is the New Georgia Project lawsuit, which seeks to enjoin the commission from further proceeding with the OSA action that that has been referred to our office in the most recent preliminary hearing. Again, we are preparing our responses to that, which will be filed by close of business tomorrow. The OSA cases that we had scheduled for hearings last month were actually settled and presented during consent order, which I will note not only is good to resolve things cooperative, but also saves money in terms of the OSA's ALJ fees as well. So it's always to be encouraged to try to resolve these matters before having to incur the cost of the hearing. We have several others in the pipeline that we expect will be calendared for a hearing between now and the next meeting, and we'll look for all opportunities to do that as well. So.
Jamie, real quick, also thank you to Ms. Young for her help with getting those cases settled. I think I left that out, but she was a big help getting those cases that we had in the pipeline settled for this meeting. So I just wanted to make sure I shouted that out as well.
Okay. Anything else, Ms. Young?
That's it. Thank you.
Okay, thank you very much. Is there anything, I guess, before we vote to go into executive session, is there anything that we need to discuss in executive session relating to any of the legal actions that are out there pending? Because I'll move to amend the agenda to add that to executive session if you think we need to.
Only if anyone has questions. You know, we're early in the process in both of those cases. And
Well, Commissioner Weiss, do you want me to add that to the executive session?
I'm good.
Told me.
I've been told I can ask her.
All right. Anyone else want me to add anything else? Okay. Well, thank you very much, Ms. Young.
no problem.
I'll go ahead and move to the next item agenda, which is number 8. It's the executive session to discuss personnel matters. I'll go ahead and make a motion.
Mr. Chairman,
Oh, sure.
Move to public comment, that way if anybody's sitting here, they don't have to wait for us to, I don't know.
Yep, it's a good suggestion. Might as well go ahead and do that. Is there anyone that's actually signed? Well, let's go ahead and just, for record purposes, we'll skip number 8 for now on the agenda. We'll go to item number 9, which is set for public comment. Is there anyone that's actually signed up for public comment today? No? Is there anyone here who hasn't necessarily signed up but is here for the purpose of public comment? Or anyone by Zoom? All right, hearing none, we have no public comment. So now, I will go ahead and make a motion that we adjourn the public session of the meeting, and we go into executive session in order to discuss personnel matters. Do I have a second?
Second.
I got a motion and a second. Any discussion? Hearing none, I will call the vote. All in favor say aye.
Aye.
Any opposed? Hearing none. At our executive session, so I'm going to go ahead and make a motion that we, again, formally conclude the executive session and re-enter our public session. Do I have a second?
Second.
I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? Hearing none, the motion carries. Following the executive session, we have one additional piece of business that we need to address prior to adjournment. I am going to make a motion that we increase the Executive Secretary, David Amati's salary by $15,000 to a total of $160,000 per year. Do I have a second?
Second.
I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? Hearing none, the motion carries. We don't see any other items that we have on the agenda. We'll move to item number 10, which is adjournment. Go ahead and make a motion that we adjourn the meeting. Do I have a second?
Second.
I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? Hearing none, the motion carries. Thank you all for a very productive meeting today.